Will the judge throw out the Petito versus Laundrie lawsuit? Well, I just watched the motion to dismiss hearing. I'm going to give you my analysis. I'm also going to give you the highlights of that hearing. And I'm also going to suggest to you one clue that this judge may not throw out the motion to dismiss, may not throw out the lawsuit. So please do subscribe to my channel. Hit that subscribe button, hit the like button. Leave a comment. I want to know what your analysis is because this video is simply my opinion. It's for education and information. So I'm also going to give you an update on the claim by Gabby Petito's mom against Brian Laundries' estate. I'll get to that at the end. So we're going to look at here, what were the questions that the judge asked, and do they indicate how the judge might rule? So let me get to the highlights, but before I get there, let me give you a little bit of background in case you pop down to this channel. So Gabby Petito's parents are suing Brian Laundries' parents for intentional infliction of emotional distress, and they're seeking monetary damages because they allege that Brian Laundries' parents, Chris and Roberta Laundrie, withheld information regarding the whereabouts, what happened to their daughter Gabby Petito, which caused them severe distress. Therefore, they should be compensated. What Brian Laundries' parents, Chris and Roberta Laundrie, have filed a motion to dismiss the lawsuit. So today, the judge heard the arguments from both sides. And by the way, the Laundries did not appear, but their attorney did. And the judge will be issuing his decision in 2 weeks, within 2 weeks. So that's by July 6th, if I did my math right. So what were the arguments that each side brought? What were the questions, more importantly, by the judge? And I think this judge asked some great questions, but I also think there may have been a bit of tipping of the hat of what the possible ruling could be. Okay, so basically what the defendants, what the Laundries are arguing is they had a constitutional right to remain silent. In other words, they didn't have to provide any information to Gabby's parents. Therefore, the First Amendment, the right to speak or not speak, applies. The Fifth Amendment, the right to remain silent. Sixth Amendment, right to retain counsel, because they had an attorney who issued a statement. But just like I said in the prior video I did on this, is that I thought that the statement that they made is speech. And I think so did the judge, and I'll tell you why. All right, so let's get to, does the Constitution apply according to the defense? Therefore, it bars this lawsuit and the judge should throw it out. Or, as the plaintiffs, Gabby's parents assert, there is no constitutional rights here because they did make a statement, okay? So, by the way, the statement is, just so you know, their attorney, Steve Bertolino, issued this statement on September 14th, 2021. Now, Gabby Petito's tragic circumstances, her remains were found on September 19th. Okay, so on September 14th, the Laundries attorney, Steve Bertolino, said the following, issued this statement. It is our understanding that a search has been organized for Miss Petito in or near the Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. Just like I said in that prior video I did, to me that is speech. Okay? There's one thing if you don't make a statement, and you can't be compelled to make a statement according to the United States Constitution and apparently the Florida State Constitution, right? But if you make a speech, if you say something, I'll get to what the judge said. And this is the clue, okay? So let me do the highlights real quickly here. And forgive me, I took a bunch of notes. It was a fascinating hearing. And if you're interested in the Constitution, or if you're a law geek like me, it was a very interesting hearing. Okay, so let's look at the questions the judge asked. Okay, because the judge is trying to get information, figuring out how he's going to rule. Is he going to grant the motion to dismiss and throw the case out, throw the lawsuit out? Or is he going to deny it and let the case proceed to trial? Okay, and I think there's a strong possibility he may deny it. Okay, may deny it. We'll see. We'll see. All right, so let's go through the highlights. So, first up was the defense attorney on behalf of the Laundries, because it's the defense that's bringing the motion to dismiss the lawsuit. Okay, they're claiming that there is no legal footing for this cause of action for emotional distress because the Laundries had constitutional rights to remain silent and to maintain their privacy, and that does not amount to emotional distress. All right, so forgive me for my rattling of pages here, but anyway, the defense attorney said, people are free not to speak, and I don't disagree with that. But it's when they speak and what they say, I think, is one of the clues. But I'll get there. So the judge said, is there a distinction between the attorneys and the Laundries? In other words, the defense was trying to argue that you can't impute the statement that Steve Bertolino made, the attorney made, which I read to you, about, we hope the search is successful. We hope that she's reunited with her family. But the judge said, is there a distinction between the attorney? And I don't think there is, because I think what the law supports is that when you have an attorney who makes statements, the attorney is acting as your agent. Okay, this could be something that could be argued down the road, but this is a motion to dismiss. That means the judge has to assume that everything that's alleged in the plaintiff's lawsuit, in that complaint, and again, go look at the prior videos I did on the motion to dismiss, look at the one I did on the amended complaint, the judge has to assume that all that is factually true. Okay? And assuming it's factually true, are those sufficient facts to support a cause of action for intentional infliction of emotional distress? So the judge says, is there a distinction? So what that means to me is, basically, I think the judge is going to say the attorney is an agent. And when you use words like on behalf of the Laundrie family, it is our hope. So that right there says that the attorney is making a statement on behalf of the Laundrie family. Okay, just my opinion. You may disagree, and I want to know what your analysis is. So please do leave a comment, subscribe to this channel, and hit that like button. So the judge said, why does it matter that the attorney or the client made the statement? See, again, the judge, I think, is concluding here that the attorney was making a statement on behalf of the Laundries. Therefore, that is speech, right? So there's two avenues you can go here. You can say, my client has the right to remain silent. Therefore, and the Constitution protects that right. Or if there's a statement, does the Constitution apply? Right? You're making a statement. You are speaking. So First Amendment, I don't think applies. The Fifth Amendment, the right to remain silent, well, you're speaking. So you're not invoking your right to remain silent. Okay, I hope this is making sense. I think it's fascinating. So the defense attorney said it's not alleged in the complaint that the statement was on behalf of the Laundrie family. I don't think he's going to win on that one, because it says clearly in the statement, which is included in the amended complaint, the four corners of the complaint, which is what the judge looks at, and it was alleged in the complaint, that statement, on behalf of the Laundrie family. It is our hope. Okay? So the judge says, assuming the court can conclude that it's sufficient that the attorney is the agent, again, the judge has to assume that all of these allegations are true. In other words, that statement was true, right? Does the defendants, the Laundries, have a constitutional right here? Well, I don't think the Constitution applies, because they did speak. And if they spoke, what happens? All right. So the defense attorney again said, they have a right to remain silent. It's constitutionally protected. I'm not disagreeing with that. But when they speak, I don't think the Constitution applies, right? At that point. So let's take a look at what else the judge said. And again, think about these questions that the judge is asking. The defense is saying, even if you consider that statement, the statement wasn't outrageous. Wasn't outrageous for them to say that. Our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. So the defense is saying, okay, great. If you assume that's a speech, that statement is them speaking, the Laundrie speaking, it's not outrageous. Well, that's going to be interesting because I think that's where this case, the decision the judge has to make, that's the most important element, I think. So the judge said, judge shifted here, and the judge said, does Florida recognize a parent-child privilege? Now, I think the judge is trying to cover all bases here. The defense said that there was there's no requirement to speak. There isn't a privilege. And the judge said, let's go down the road. I fully understand the constitutional right to remain silent. So the judge gets that argument. Okay, but again, it's a fork in the road. Did they speak? And if they spoke, what's the next thing? If they didn't speak, if they remained silent, yes, I can understand, and I think the judge would agree, that the Constitution protects your right to remain silent, right? But if they spoke, I'm going to get to that part. All right, so the attorney said that, let's see here. Sorry here. Let's see. So the judge said, again, reminding counsel, I have to assume all the facts are true because it's a motion to dismiss. And the defense said that the Constitution in Florida and the United States apply, right? That they have a right, their silence. They have a right to remain silent. But again, like I said in my prior videos, that statement, I think, is speech. They did speak. Okay, which could be argued. All right. So they also said you don't need to look outside the four corners because, again, the judge is limited to the four corners of the complaint. Don't need to look outside the four corners of the complaint because the complaint does trigger the right to a Fifth Amendment. Again, I think the defense is focusing on the constitutional right to remain silent, where I think the judge is pivoting and saying, what about that statement that Bertolino made on behalf of the Laundrie family? Isn't that speech? All right, so let's go to the next part. So the judge said, again, going back to the allegation, saying that the Laundries, assuming the Laundries did make an affirmative statement, that statement issued by Steve Bertolino, the judge said, am I not supposed to consider that as conduct? So in other words, they did take an action. They spoke through their statement issued by their attorney. Maybe that's what the judge is getting to. The defense said, assuming that that is an affirmative statement by the Laundries, is that statement sufficient alone to reach the outrageous standard? Because they have to meet the four elements for the cause of action of intentional infliction of emotional distress. They have to plead sufficient facts in their complaint. So the defense attorney here is saying, okay, great. Assume that's a statement made by the Laundries. The statement that Steve Bertolino made. The question is it outrageous? That's interesting, okay? So the judge went on to say, the defense attorney went on to say, speaking through attorneys are foundational rights. Well, you have a Sixth Amendment right to retain counsel. You have that. That's a constitutional foundational right in the United States. You have the right to retain counsel. But this speech by your attorneys, is that protected by the Constitution? I don't know about that, right? So, it does bring up the point, if the judge does deny this motion to dismiss and decides to let this case proceed to trial, guess what? I think if the Laundries are required to, submit an answer the allegations, which if the motion to dismiss is not granted, right? It proceeds to the next stage. The Laundries have to file an answer, and in that answer, they could be pointing the finger at their attorney, saying he didn't act under our responsibility. And again, the jury might have to decide this. this may be the question, right? Did Bertolino act on behalf of his client, the Laundries? I think there's a good argument to say that he did, because it clearly says on behalf of the Laundrie family, right? So we'll have to see how that goes. So the judge said, aren't we, here it is. Here is the clue. And I think this is the clue. Here's what the judge said. When the defense was saying, the question is whether or not, basically the question is whether or not the statement by the attorney was outrageous. And here's what the judge said. Aren't we responsible for the words we say? Right? Aren't we responsible for the words that we say? So in other words, if you issue a statement, if you do speak, are you responsible for what you said? Right? So they issued this statement, and the words of this statement, are the Laundries responsible for this? In other words, is there liability, okay, for the statements? But I think that's the clue. Aren't we responsible for the words that we say? Again, a jury can decide whether or not they're liable for this, whether or not that statement was outrageous to meet the requirement of outrageous conduct for their cause of action. That could be debatable by a jury, right? Question of fact as to whether or not, Bertolino, their attorney, what knowledge he had when he made the statement, whether he was acting on behalf of the Laundries, etc. That could all be argued. We're at a motion to dismiss here, so the judge has to assume it's true. And based on that, is it outrageous conduct to issue this statement during the time at which there's a search for Gabby Petito, and they make these statements? They make this statement. Okay, so let me move on here. And the judge brought up the fact that, Johnny Depp was held liable for defamation civilly, right? In the recent case, and I think also the case in England. So the defense said the statements could lead to defamation, but here the statement by the attorney isn't defamatory or outrageous. So the defense is trying to argue, okay, judge, you assume it's a statement. They did speak, but it's not outrageous conduct for what they said in the statement. The judge said, again, reminded counsel, I have to accept as true everything that's alleged. And the judge said, here's another clue. They made the statement knowing exactly where Gabby Petito's body was. So at the time that this statement was issued, assuming the allegation is true, and the judge has to assume it's true, that the Laundries were told by Brian that he had murdered Gabby, the judge is saying here, they made the statement at the time when they knew exactly where Gabby Petito's body was. So in other words, isn't that outrageous that they make this statement here? And I'll get to what the plaintiff's attorney, the attorney representing Gabby's parents, get to. Okay, so hang on for that. So the defense says here, which is interesting, the Laundries attorney says here, the plaintiffs have not alleged in their complaint anything regarding what knowledge Steve Bertolino, their attorney, had, that he had that information when the statement was made. So again, aren't they going to be pointing the fingers, the Laundries potentially pointing the fingers and saying the responsibility, liability rests with their attorney, not with them? And I think the defense is also arguing there isn't sufficient facts in the four corners of the complaint to say that their attorney, Laundrie's attorney, knew at the time where Gabby was or knew any of this knowledge at the time the statement is. But the judge still asked that question. It was made at the time when knowing exactly where Gabby Petito's body was, allegedly, right? Again, the judge has to assume everything that's in that complaint is true. So again, here's what the defense says. They're trying to argue now the statement is not outrageous conduct because the statement is benign and it's generic. Well, again, I don't know if you think the statement is benign or generic, but, again, look at the statement. Then the judge says, isn't the context important here? In other words, when the statement was made, what was the context of what was going on? There was a search underway, right? So are we responsible for the words that we make, that we say? So, all right. Interesting. The defense tries to argue it's benign and generic statement. I don't know about that. So again, the defense reminds the judge that the Laundries are simply asserting their legal rights to remain silent, and that the plaintiffs have not shown that there was any constitutional right not to speak. Okay. So again, let me restate that. So the defense again was going back to saying that the Laundries had a right to assert their constitutional right not to make a statement, not to speak, not to incriminate themselves. But again, there's the fork. I think the judge is saying there is speech because of that statement that was issued by the Laundries attorney. Okay. So they went into that whole, state action. So the plaintiffs are trying to say there's no state action, therefore the constitutional rights don't apply. The defense is saying, yes, there is state action because the judge is going to make, somewhere down the line, there'll be a judgment in this case. So the the judicial branch is getting involved. So therefore there's state action. Again, I think that whole state action, just my opinion, I think the state action argument is red herring because the question is, was there speech? Okay, that's the question. Did the Laundries speak? And I think it can be argued, like I said in the prior video, that this statement is speech. Therefore, they weren't being silent. Therefore, they did take affirmative conduct by issuing this statement. Okay, so the Constitution doesn't apply. I don't know, we'll see. All right, so let me see what else we have here. Then they got into the argument about the Fifth Amendment, the right to remain silent, right? If you're not to be compelled to give any speech where you can incriminate yourself. Fifth Amendment in the U.S. Constitution. So the judge asked, assuming everything that was alleged in that complaint is true, is there any other crime that the Laundries are accused of? The judge says, does there have to be a crime for the Fifth Amendment to apply? The defense said, doesn't have to be a crime. You just have to be in jeopardy of a possibility of being charged with a crime. The judge said, doesn't the causation have to follow the causation towards a crime? Now, in my opinion, I think this is a red herring again, because the Fifth Amendment, your right to remain silent, but were the Laundries being silent? Because this statement is not silence. This statement is speech. So I don't know, the decision here has to be one of two ways. Either they were silent or they spoke. Okay? So that statement issued by the attorneys, is that speech imputed by the Laundries? So we'll have to find out. So the judge said, here's another clue. What's the crime here? Because the Gabby's parents, the plaintiffs, alleged in their complaint that the Laundries were making arrangements to get Brian out of the country. In other words, aiding and abetting, harboring a fugitive possibly. Again, I covered this in the video I did about the possible crimes that the Laundries could be charged with. You might want to take a look at that. I don't think aiding and abetting applies here. I'm not aware, again, I'm not a Florida attorney, but I'm not aware of a crime that the Laundries have committed at this point. But I don't think that's required. I don't think there has to be an active investigation or a warrant issued or a crime. And I covered this in the prior video because I think the Fifth Amendment is broader than that. But again, the Fifth Amendment is the right to remain silent. That statement is speech. So they're not being silent. You see what I'm saying? We're back to that fork in the road. All right, so what else? Again, the defense reminded the court that the Laundries have a constitutional right to remain silent. Okay, so now we have the plaintiff's counsel. So Gabby Petito's attorney, what were their arguments? They said it's not simply about silence. It's about a course of conduct that the court pointed out already, that conduct includes the statement they made. So Gabby's parents are arguing, the plaintiffs are arguing, they weren't silent, they issued a statement. So the judge said, what duty do the Laundries have to help? What duty do the Laundries have to help the Petitos, the Petito Schmidts, to Gabby's parents? Which I think is an interesting question. What duty? But I don't know that they have to have a duty for intentional infliction of emotional distress. Okay? The plaintiff's counsel said it's about what they did with the information they had. They could have made an anonymous phone call and given the information, and that they knew on August 28th that Gabby Petito was dead, and they knew where her body was. Again, the court has to assume that the allegations that Brian told his parents that he murdered Gabby Petito, the court has to assume it's true. And Gabby's parents' attorney argues they did things affirmatively. They didn't remain silent. They issued this statement. So the judge says, getting back to the legal duty, I want you to focus on the legal duty. Did the Laundries have a legal duty to the Petito Schmidts? The attorney representing the plaintiffs, representing Gabby's parents, said, Your Honor, I'm struggling with whether or not they had a duty. And again, I don't know that they're required to have a duty, but I think the judge is just inquiring here. Maybe it could have been argued that there was a special relationship because Gabby Petito was engaged to Brian Laundrie. I don't know that amounts to a duty. I don't know. But let me move on here. So here's what I think is going to be really interesting. And again, I said this in the prior video, that Gabby's parents' attorney is saying the statement they made, the one that I read to you, and I'll read it to you again. It is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. The Gabby Petitos, the plaintiffs are arguing here that statement amounts to giving giving false hope that their daughter is still alive. And that's outrageous for them to issue this statement to give Gabby's parents a false hope that they would find her, and that false hope that she was still alive. I think that's a really interesting argument. So the judge said, how is this statement that we hope her search is successful outrageous? Again, back to what I said here. The judge is focusing on, okay, that statement is speech, but is that statement outrageous? So is that statement sufficient facts to support a cause of action for emotional distress? So the judge said, how is that statement? We hope that the search is successful. We hope that that Gabby is reunited with her family. How is that outrageous? Well, I think it might be argued that it could be outrageous, right? Because a search is going on. They issue this statement, which can be argued giving false hope that Gabby Petito is still alive. And that's outrageous conduct. All right. And so what does the plaintiff's attorney say here when the judge says, how is that statement outrageous? And I think this is what I said in the prior video, because the statement is a lie. That's what they're arguing. They're arguing it's a lie because they're giving false hope that Gabby Petito may be alive. It's outrageous to issue that kind of statement. They gave them false hope that Gabby Petito was still alive, and that's outrageous. Because they could have said something else. They could have said nothing. The attorney could have come forward for the Laundries and say no comment. The attorney didn't have to speak, but they spoke. And they spoke on behalf, which is what they're arguing here, the plaintiffs are arguing, on behalf of the Laundries. So they also, and I pointed this out in the prior video, the plaintiff's attorney argued that I think it's the Thomas case, where the doctor, the doctor concealed how the patient actually died. Patient came in for hip surgery. They told the patient's family that the reason the patient died was because they had a cardiac arrest. When in truth, they gave the doctor and the nurses, allegedly, gave the patient a lethal dose, and that's what killed him. And during the funeral for the mother who died, the daughter was contacted by the medical examiner and asked to do a second body, to return the body to do a second autopsy, because the medical examiner had found out the true cause of the death wasn't the cardiac arrest, it was a lethal overdose. But the doctor and the nurses covered up, they concealed that. It was a lie. So isn't that similar here? Couldn't that be argued here that it was a lie? This statement that was issued by the Laundrie's attorney was a lie. I don't know. We'll have to see. So let me see what else here. Hopefully this isn't too long. Again, they brought up, isn't it false information in that statement? It was a false impression that Gabby Petito was still alive. When they knew that she wasn't alive, and they put out a statement as if they were supporting, it's our hope that you find her, that they were supporting Gabby's parents. The attorney said it was callous, it was shameful, and it was outrageous conduct. And they also indicated, by the way, we would have named Steve Bertolino, the attorney, as one of the defendants in this lawsuit, but because he's not a resident of Florida, they didn't name Steve Bertolino as one of the defendants. Very interesting. Doesn't mean, like I said earlier, it doesn't mean that the Laundries will not be naming or trying to shift the responsibility by naming Steve Bertolino in a countersuit, or actually a cross complaint, naming Steve Bertolino for the one who's responsible for the statement. Okay, making him responsible for this lawsuit, not the Laundries. So that'll be an interesting question. So the judge said, you allege that the conduct was criminal. He says this to the Petitos attorney. Why can't I consider the constitutional rights in the motion to dismiss? Again, the judge is getting back to, okay, if you don't consider that statement as speech on behalf of the Laundries, then we go back to the Laundries' right to remain silent. And the judge is saying, why can't I consider the constitutional rights? And I think the judge can, right? The right to remain silent. So the judge said, not sure if the absence of charges is the criteria. So in other words, in the complaint, the judge is saying there's no real charges that have been alleged in the complaint that's saying the Laundries are harboring or aiding and abetting, that kind of stuff. And the attorney says you don't have to go outside the complaint because you can look at the face of the complaint, and within the four corners of the complaint, there's no suggestion that the Laundries committed a crime. Therefore, the Fifth Amendment doesn't apply. Okay, so again, they're shifting. The judge is covering all bases here, saying, okay, the right to remain silent. So they're not, judge is saying, I'm not looking at the speech, the statement, the alleged statement made by the Laundries through their attorney. Now I'm going back to what if the right to remain silent applies? And the Nichole Schmidt's attorney is saying, Your Honor, it's not, we're not suggesting that there was a crime. Therefore, the Fifth Amendment doesn't apply. But the judge said, given paragraph 30 of the amended complaint, and you can look at the video I did on the amended complaint, where the plaintiffs alleged that the Laundries were making arrangements to get Brian out of the country, the judge said, aren't the plaintiffs alleging that that is criminal activity, and that isn't that a basis for me to consider the constitutional rights? So because they put that fact in their amended complaint, because Gabby's parents put that fact about Brian's parents helping Brian, making arrangements for Brian to leave the country, the judge is saying here, well, that could amount to some criminal activity. Therefore, it triggers the Fifth Amendment, the right to remain silent, so they can't compel the Laundries to speak. Okay? That's interesting too. So then the judge said, well, again, let's go back to the duty. Do they have a duty to speak? And the attorney says, it's, I'm not being critical of them retaining a counsel, right? Sixth Amendment, but it's the statement that they made it's circumstantial evidence that the attorney knew at the time what it is that the Laundries knew, that they alleged that the Laundries knew Brian killed Gabby and Brian knew where Gabby was. So the judge gave the defense their opportunity to rebut, because it's their motion for a dismiss. So the defense went into the fact of, one of the other elements they have to show is that that the Petitos and Schmidts have to show is that the Laundries directly caused them harm. So were they physically injuring the Gabby's parents by their statement? Was it directly targeted towards Gabby's parents? So what did the court say? Let's see. And they argued that the court can't assume that the statement, well, let me put it this way. They're saying that there was no direct conduct. So the Laundries are arguing there's no direct conduct towards the Gabby's parents because basically this statement was issued to the public, right? It was issued to the media. So therefore, they didn't make that element of showing that it was directed, the harm was directed towards Gabby's parents. So the judge said, I will issue a written order within 2 weeks. So by July 6th, we'll get a written order. But I think, are we responsible for the words that we say? And the judge, went down both forks of the road. If you're going to say that they were silent, you're not going to impute the statement by their attorney as speech. So you're not going to consider, judge doesn't consider that statement. So the Laundries had a right to remain silent. And if they do, you can look at all the constitutional rights. Okay? But if the court says that that statement through their attorney can be imputed, saying the attorney is an agent of the Laundries, that is speech. So the right to remain silent, Fifth Amendment, the First Amendment, to speak or not to speak. The question is that statement an outrageous conduct? Right? It was issued at the time they were searching. Was it a lie? Did they give false hope that Gabby was still alive? That's why I think the judge may not dismiss this case. Okay? I think the judge might reason, I don't know. The judge might reason that those facts that were alleged, this statement is enough to show that there was outrageous conduct, right? Because if you have a doctor who conceals how a patient was actually died, I should say, right? They said it was a cardiac arrest. It was actually an overdose that the doctors injected and they covered that up. Is that a lie? As the attorneys representing the plaintiffs are arguing here, that statement was a lie and it gave them false hope and they should be held accountable for that statement. And that statement, what they said was outrageous conduct. I don't know. What do you think? What's your analysis? All right. So last thing I want to get to, it was fascinating, I think. And I encourage you to look at the prior videos if you, to give yourself more context about all the cases that they were arguing, etc. But, it comes down to, was there speech by the Laundries? Is that statement that was issued by their attorneys constitute speech? And if it does, the constitutional right to remain silent, all of that stuff doesn't really apply. The Fifth Amendment, right to remain silent and incriminate yourself. Well, they made a statement. That is speech. That is conduct. Okay? So we'll have to see whether or not the judge thinks that's sufficient to constitute outrageous conduct. I think that's the real issue. All right, so quickly, a quick update here. There was a second matter that the judge took. It was a case management conference regarding the lawsuit that Gabby's mother, Nichole Schmidt, has filed against Brian Laundries' estate. Not against the Laundries, but against Brian Laundries' estate. And the judge asked whether or not there was any appearance by anybody representing the estate of Brian Laundrie. Nobody appeared. The plaintiff's counsel, the counsel for Nichole Schmidt, said that they're going to give an additional 20 days for someone to respond to this damage claim that they're seeking. I think Nichole's mom is seeking, I think, $30,000 to $50,000. It's probably funeral expenses that they want to recover for Brian Laundries' estate. So the question is whether or not that case is going to be in default. In other words, nobody makes an appearance. And so if there's a default, nobody makes an appearance on behalf of Brian Laundries' estate, the judge will set a trial, a jury trial, and the plaintiffs have to put on their case and show that, Brian Laundries' estate is responsible for these damages. So I'll get into that later, but I just wanted to give you the heads up on that. So you let me know what your analysis is. How do you think the judge is going to rule? Do you think the judge is going to throw out the Petito versus Laundrie lawsuit? Do you think that statement by Steve Bertolino, the attorney, can be imputed on the Laundries? Does an attorney who stands up and makes a statement on behalf of the Laundrie family? I mean, this is a tragedy for everybody involved here. Okay, and it's fascinating for me legally looking at this because there are, potentially constitutional questions here if there is no speech. But I think it may be even better argued. I don't know. What do you think? That there was speech because the statement. I mean, do we allow people to make statements that are potentially misleading or false and they have no liability for that? Especially during the time you're looking for your daughter? I don't know. What do you think? I mean, is that outrageous conduct? All right. So you let me know what you think. Please do leave a comment. I want to know what you think here. What's your analysis? Please leave a comment. Hit that like button. Do subscribe. Please do support my work. And if you want to support me making these videos, I'll put a PayPal link in the description box below the video. So again, look at the prior videos I did, right, to get the context of all of this if you want to catch up. So please do leave a comment, and thank you very much for watching, and please do subscribe.